At Raju Law, we don't just provide legal services. We provide a pathway to your American dream. With offices in New York, Los Angeles, Washington, D.C., Atlanta, Dhaka, and Dubai, our global team is dedicated to delivering personalized immigration solutions. Whether you are pursuing a green card or navigating complex immigration processes, we are here to guide you at every stage. With a team of 10 associate attorneys and more than 180 law clerks and case managers, we craft solutions tailored to your unique needs. Our technology-driven platform ensures the fastest, most efficient service, saving your time while upholding the highest standards of quality. At Raju Law, we believe in affordable, transparent pricing without compromising on service excellence. Raju Law, where your American dream meets expert legal support. Contact us today.
Welcome to Raju Law's Monday Live. I am Manshi Katira and Assistant Manager at Dubai branch at Raju Law, and I will be your host for today's session. As always, we are thrilled to have our amazing audience joining us from all around the world. If you are watching us on Facebook or YouTube, don't forget to drop a hi in the comments and tell us where we are tuning in from. Today's topic is an important one of our many of our viewers, especially NIW pitfalls and common questions. The NIW, that is National Interest Waiver, is one of our most sought after US immigration categories. But it can also be one of the most misunderstood. Many applicants face delays or rejections simply because they are unaware of the certain common mistakes. To guide us through this key insights, we have a very special guest with us, Ms. Chelsea Smith, supervising attorney at Raju Law. Chelsea is an exceptional skilled immigration attorney with a very strong background in a multiple legal field. Antitrust, corporate real estate, and immigration. She holds a master's in environmental law and policy from Vermont Law and Graduate School and a Jewish doctor, Elon University Law School of Law. With her multi-facet experience and dedication to helping clients navigate the complex world of immigration law, Chelsea brings both expertise and empathy to every case she handles. So, without further delay, let's welcome Ms. Chelsea Smith to our today's live session.
Good morning. Thank
Hi,
you so
Chelsea.
much.
How are you?
Doing well, Manshi. Thank you for having me today. It is a pleasure to be here, and we're looking forward to this discussion about the NIW pitfalls and common questions. Can you see my slides okay? I think we can. Okay, so today we want to discuss pitfalls of the NIW, specifically why generalizations fail in 2025. This is kind of an emerging topic. We saw it before, but especially following that January 2025 policy update from the USCIS regarding the NIW petition evidentiary requirements, we are definitely seeing more complications or more challenges for evidentiary requirement. That is why generalizations typically fail. But let's get into a more in-depth discussion of what this means and how to overcome it. So in previous Monday live sessions, we have discussed the importance of tailoring your proposed endeavor to your specific expertise, to your specific niche within your practice area. And the reason that we emphasize this is because we want the proposed endeavor to highlight what you have intended to achieve in your future plans in the United States. This allows us to then align the substantial merit and national importance. We can also show how it's imperative with more clear, concise language. It ensures that the officer is able to more easily understand the content, more able to appreciate the niche aspect of it or the unique attributes that it may be delivering to the United States. In this presentation, it is for educational purposes only. It's not intended to be legal advice. It's not intended to be, very specific information. These are general concepts that we're discussing today, and we just want to take a moment to remind you of that. We will be able to provide, broad information to this crowd today. And the importance of specific NIW proposed endeavors, we also want them to be concise. This includes what we call SMART goals. SMART goals stands for having specific, measurable, achievable, and time-bound goals, and they can be broken down into short-term and long-term objectives. A detailed description of the methodologies, the advanced skills that you will be using to achieve your goals is imperative. And making a clear connection to that national interest. We want to show the USCIS that it is imperative that your objectives get executed in the United States, and it is in the United States' best interest to approve this petition based on the alignment to, we want to make a clear connection to a U.S. interest in that proposed endeavor. So that leads us to pitfalls. And why did I start with the proposed endeavor? And the reason that I started with the proposed endeavor first is because that is where the backbone of the petition is formatted. If you're familiar with the NIW, you know that you have to have a prerequisite education, and you know that there's a three-factor analysis. And so how is that all evaluated? Well, it's evaluated against that proposed endeavor, which is a common misconception of the NIW. So that is why I started off with the importance of a specific, concise, and clear proposed endeavor leveraging SMART goals. So that leads us to pitfalls. So these pitfalls that we're going to discuss, they will weaken your proposed endeavor. They often are the most common reasons for the NOIDS, RFEs, or a denial. And these issues are something that they're easy to fix, but they also require a lot of focus. They require a lot of engagement with clients, and typically it's not something that an attorney can overcome without participation with the client. The reason being, we are not experts in your field. And that comes through. It reduces authenticity. It reduces the specificity that an expert can provide about their own skills, about their own plans. You know your plans best, and therefore that's how this kind of relationship becomes highly imperative through this process. So let's talk about pitfalls. We mentioned vague and overly broad description of your work and goals. We don't want this to simply be a continuation of a job you are already performing in the United States. We want it to come across, it should come across more of research, it should come across more as project and collaboration and societal impact. And so simply continuing your job seems passive to the USCIS. A lot of times you can continue your job as a means to executing the proposed endeavor, but we have to be cautious and make sure that, it's being framed in a way that it isn't seeming passive to the USCIS. We want to have active engagement. So that leads us to the next thing about we want you to have narrow impact, or narrow impact meaning a narrow focus, so a specialization. But we need to have a broader impact so that it's clear that it will reach the broader United States on a national level. We don't want it to just simply align to your current employer's objectives, because the USCIS does not find that even a global employer, if you're simply aligning to their objectives, they don't find that company objectives are necessarily national objectives. And so we're seeing those kicked out right now for that reason too. Similarly, kind of dovetailing off of that is failing to draw a clear connection to national interests. Again, company interests are sometimes driven by national interests. They're sometimes driven by federal initiatives that are active, federal funding. However, private companies tend to have their own objectives as well. They're trying to do things that benefit their bottom line at the end of the day. So with that in mind, failing to show alignment to national interests could be a reason for weakness in a proposed endeavor or a petition itself. Focusing on the importance of the field rather than the petitioner's contributions. And I like this one a lot. And I'll use the example of AI, or artificial intelligence, as you may know it. As we know, the digital interface is touching a lot of industries, right? Most industries are having to transform for this digital interface that is coming through. And so the USCIS doesn't have to be sold on the value of a digital interface in multiple industries. They don't need that confirmation. What they are focused on is making sure that your specific contributions to your field are of value and of national interest, and that you're well positioned to do so, and that there's an urgency to support the approval of an NIW. So if you think about it in contrast, you don't have to sell the benefit of AI to the United States. What you need to sell, or what you need to portray in your proposed endeavor, is your contributions to AI. Is it in the healthcare sector? Is it in the telecommunications sector? Is it in, public health? Like, what are you doing specifically with the proposed endeavor? And it can't be that you're doing everything across the board. The USCIS has rejected that position. So that's what we mean when we say focusing on the importance of the field itself rather than the petitioner's actual contributions. There can be a distinction there. They can go hand in hand, but we should always prioritize that petitioner's contributions, and making sure that the proposed endeavor that you provide also does that. We want it to highlight your unique skill set, your unique contributions, and your unique plans for enhancing the industry and the nation at large. So lastly, the common pitfall that we're seeing right now is insufficient evidence. So the USCIS is pushing back for higher evidence. They are rejecting kind of what I call softer evidence in support of petitions. They are wanting to see measurable impacts. They're no longer excited by, memberships alone, high salary alone, or letters of recommendation, kind of giving broad generalizations. They're really wanting specific objectives that the petitioner has achieved. They're wanting to see how they have distinguished themselves and created themselves to be an impetus in their field. So that is an ongoing standard that the USCIS is challenging petitioners to achieve at this time. So is your work being honored in media formats, recognition of some kind? Are you receiving promotions based on merit, not just years of service, but actual merit? Are you receiving performance-based recognition for your contributions? Are you publishing publications in peer-reviewed journals that are then being cited by other industry leaders? If so, then those are all stronger pieces of evidence that can support the USCIS in finding stronger ties to your proposed endeavor, stronger ties to that well-positioned aspect, and your national importance. So keep in mind that evidence could change case by case, depending on, we want to leverage the things that are the strongest for you in your specific endeavor, in your specific industry. Take a look at your resume. That's a great place to start if you are looking for maybe evidence that could help build your petition, or get an idea of what evidence you may need. Taking a look at awards you've received, publications you've been awarded, or other kinds of salary earnings is a great place to start. And I've pulled some questions today. I think that sometimes questions and answers is a great way to kind of learn a little bit. So I've pulled a few questions for you today. The first question is, can I use the same proposed endeavor that someone else used if we are from the same field? I like this question because it's asked more times than it surprised me by the number of times I'm asked this question. And the answer is it depends. That's a classic attorney question, response. However, it's unlikely that any one proposed endeavor could really work for a second person. And the reason is because the NIW is such a unique visa. It has a pathway that's based on authenticity, on your own being an impetus in your field. And if multiple people are doing the same thing, how does that show that you are an impetus in your field if you're doing the exact same thing? So typically I don't encourage it. I think that that's probably a bad approach, generally speaking, because you lose that ability to be authentic in your role. You lose that ability to sustain, a narrative that's really true to your skills and your attributes. And honestly, at the end of the day, that's where a proposed endeavor can really distinguish itself if it is authentic. They can tell someone who's very passionate, very skilled right away. That conveyance of the information, the details, the plans, it all comes across with a lot of just authority and just passion and a declaration of expertise that's just more undeniable. So for that reason, I don't encourage reusing proposed endeavors from friends or roommates or that you get online. I encourage you to craft your own with the help of a legal expert is probably best, but otherwise I would encourage you to really keep it authentic to yourself. And this question is coming up more and more also for someone who has never worked in the United States. You talked about being specific. How do I prove my work helps the United States? And I like this question because it is imperative. You can have a proposed endeavor that has national importance, that has, alignment to things that the U.S. is caring about, that you have experience to support your proposed endeavor. But at the end of the day, if your work abroad hasn't already benefited the United States, then it can kind of weigh down on that third prong, which has to show urgency and that you've already benefited the United States in some way. So how do you do that? And the answer is it will depend on your expertise. It will depend on your personal trajectory. But generally, what we need to do is create a narrative or an understanding of how your work has benefited the United States, either directly or directly from abroad. If you haven't worked on international or national level projects in your home country, it's typically not likely that you would be able to meet this threshold. So that's something to consider also. However, those of you who are working abroad and you're working on, I just worked with somebody who was an engineer at an international organization, and we were able to look at his company's relationships with U.S. Initiatives. They had direct relationships with U.S. for the oil and gas industry, direct relationships for an engineering industry, direct. They were developing technology and software together is what we found. And so we were able to leverage that pretty successfully for the client. And then what I'm getting at is that there are a number of international relationships that we can successfully leverage, we can successfully lean on. But this general acknowledgement here that if you're not working on national level projects in your home country, it's unlikely that you would have met the international level. Typically, national level projects are the ones that touch international contributions. So again, it's a case-by-case basis, but that's a great place to start with assessing your work. And this question is interesting also. It says, can I apply with a bachelor's degree from Bangladesh? And the answer to that is that it depends on your work experience and other skills. Typically, a bachelor's degree alone is not sufficient for the NIW educational requirement. However, there is an exceptional ability framework. It's a 6-factor analysis that you can get with a bachelor's degree in 5 years progressive contributions. It's a higher threshold. It's a little bit more difficult. There's 6 factors. You have to meet 3 of those 6. I won't say it's impossible. There are some people who have done a really great job. They have a really great portfolio that's prepared them. But I would say that there's a higher threshold or a heightened scrutiny for demonstrating that you truly are an impetus within your field. If you choose to do that route, we have to make it very, very clear to the USCIS that you do distinguish yourself, that you have a high salary, you either have a license or a degree, you have awards, recognition, memberships, contributions to your field that have had a measurable outcome. So all of that gets assessed, up front in the exceptional ability prong, but also again, throughout the rest of the petition, we can leverage that information for other issues such as like the well position. Some of the national importance can come in with that as well. And this question is, can I write that I want to start a company or build a product in the United States? Will that help or hurt my case? And I like this because there are a lot of entrepreneurs or people who are aspiring to be an entrepreneur to reach that broader impact requirement of their proposed endeavor. And I think that this is a pertinent question because entrepreneurship is allowed. It's not that it's not allowed. But what I like to caution is that it will be reviewed as, if you choose entrepreneurial skills for your short-term goals, you will be evaluated as an entrepreneur and as an expert in whatever your field is. And so I tend to find that if you want to do something entrepreneurial, given the logistics of, you'd have to take a look at your visa, whatever visa you're on, the constraints you're on, the financial feasibility. You would have to take a look at all of that information and, argue that not only are you in a position to be a successful entrepreneur, but you're also in a position to be a successful expert in your field. And I think that's typically a threshold that's not sustainable for most people. So typically, I encourage that could be a long-term objective. It can be one of your long-term objectives. I don't typically recommend it as a short-term objective. Of course, there's always going to be exceptions. There's somebody who is probably watching this who has maybe extensive entrepreneurial skills, and that could be grounds for possible exception to that. But generally speaking, while it is permitted to have entrepreneurial skills in your proposed endeavor, I typically don't encourage it as a short-term goal. It can be part of your long-term portfolio, though. This question asks, can I mention collaborations I want to pursue in the future, even if they are not confirmed yet? And I think that it's typically great advice here. You can always mention collaborations that you want to have, but it's more probative to the USCIS if there's also letters to go with it that says, hey, your proposed endeavor focused on public health research, an email from the NIH that just says, hey, we're looking forward to collaborating with you in the future on your research focused on whatever public health issue you're looking for. Any kind of award, recognition of collaboration is much more probative than simply saying this is what I will do or this is what I want to do. It's certainly helpful information to say, these are my future plans for collaboration, but having some kind of traction toward achieving that collaboration already in hand is much more probative to the USCIS. It's much more compelling to them that you can actually achieve this, and it's not just some kind of dream that you're coming up with without an actual, direction to put in the work or to make the connections or earn whatever collaboration you may be seeking. It also is helpful if you are already an employee at a nonprofit or some kind of federal agency that is focused in your field of expertise. If you've already been invited into past projects, it tends to be well received that it's likely that you're already in connection with, the channels that would allow you to have future collaborations. So I think that this could be helpful to say, I specifically plan to collaborate with these entities or these agencies or these nonprofits, but it's even more compelling to have already had some experience and to have some evidence to support their interest and or your past experience. And these are the questions that I've put together. We have a couple more minutes. We can take a few more questions. I see one question here that I'll go ahead and answer, and then I will defer back to Ms. Manshi for the rest. It says, can someone apply for EB2 NIW without recommendation letters? And this is another great question. I don't see this question asked as often lately because most people want to provide letters of recommendation. And I think that the thing to note here is that the USCIS does not require letters of recommendation, just like they do not require publications. But the big thing to remember here is that if you don't have publications or you don't have letters of recommendation, then you must have compelling evidence from some other source. And so do you have sufficient awards? Do you have sufficient recognition? Do you have sufficient, other ways to credibly verify your contributions to different research or projects? I like letters of recommendation for those in the industry field because if they have a more industry approach instead of publications, then letters of recommendations allow us to verify their role with certain projects, the certain objectives that were being sought through the project, confirmation of the petitioner's contributions, and get some insight as to the value of the proposed endeavor from an expert opinion. So we have seen that work before, but again, the other evidence had to be much more probative and compelling. And in the post January 2025 policy update, I definitely encourage strong letters of recommendation where possible. That's definitely one key that can definitely elevate a petition by having that credible expert testimony saying that the petitioner has made themselves an impetus in their field. They are pursuing something meaningful and that will have national impact in the United States, and that they have worked in certain projects in the past and that their past projects or past contributions have already enhanced the field. So you can see it's a multi-factor kind of opinion that can be added just through simple letters of recommendation. So I love them. I think that letters of recommendation are helpful, and I would encourage everyone to pursue those if possible. Okay, Manshi, I can turn it back over to you.
Thank you so much, Chelsea. And this was a very detailed and insightful presentation. Now we will go ahead and take a really short break, like let's say 1 or 2 minutes before moving on to our Q&A sessions. So please stay tuned. We will be right back.
Thank you.
At Raju Law, we are proud to offer one of our most promising services, the EB2 NIW application. With an incredible success rate of 94%, our team has helped more than 1,000 clients navigate this efficient route to permanent residency in the United States. EB2 NIW allows highly skilled professionals and individuals with exceptional abilities to apply for a green card without the need to find an employer sponsor. Whether you're a scientist, engineer, doctor, or entrepreneur, this visa offers a unique opportunity to live and work in the United States based on your qualifications and contributions. At Raju Law, we're here to guide you every step of the way, making the process seamless and stress-free. Contact Raju Law today for the free EB2 NIW evaluation and start your journey.
Welcome back, everyone. That was a very... Hello? Hi.
Hi, I hear you.
Yeah, hi. Welcome back, everyone. Okay, so now we will move ahead with our Q&A sessions. So we will first see if there is anyone who has asked any question in a comment section. So I think you have already answered one of the questions which was asked by Eric, right?
Yes, I did.
Yes. So we will go with the another questions, which is, does filing perm in a parallel with NIW create any conflict of interest or raise red flags with USCIS?
Sure, that's a great question. And
Mm-hmm.
so typically the perm application does not interfere with the NIW itself. And I say typically because, there's an infinite number of background scenarios for a client. I also, I always recommend that you consult with an immigration specialist for, case specific inquiries. Typically, I will say that you can file for the perm and the NIW simultaneously. There is no conflict. The EB2 and the EB3 priority dates are typically factors for your consideration if you're looking for, like a faster priority date or something like that. You could always apply for both. And then if your NIW, of course, works out, then that typically is a faster priority date for you. But I think that in terms of if you're wanting to determine which one to prioritize, I think
Mm-hmm.
that if you're a good candidate for the NIW, it just really depends on your values and what the petitioner wants to achieve. If the fastest possible green card is your objective, then the NIW will get you that faster typically. But that's not to say, if you have a weaker NIW case, that it may be smart for you to go ahead and apply for the perm as well. So I think that that would be, like an individual thing that you have to weigh out and could best be consulted with a legal professional based on your circumstances.
Perfect. We have one more question, which is, how many meetings do you organize with your clients during the entire process? Asked by MBS CO. Yeah.
Yeah, so that's a great question also. For our clients at Raju Law, you'll have direct access to our team, right? And so in terms of meetings with our drafting team, we typically do 2. By the time it gets to us, the evidence is pretty well put together. We kind of know where this is headed, and it typically shouldn't take more than 2 meetings to get this figured out. Now, in terms of your onboarding process, our policy is a little bit different there. It depends on the complexities of your case. We always provide adequate support for our team members, for our clients who are wanting to onboard with us and are facing complications. I can't speak exactly to how they do the onboarding process. I know that we are very, very hands-on, we're very collaborative, and our clients always have access to us. So that's something you could look forward to with our law firm. I can speak on the drafting side, which is the part that I typically focus on. You get 2 meetings with us, and we can work with you in that time frame to address, drafting, legal strategy, things like that.
Wow. Perfect. My next question is, how does filing both NIW and PERM in a parallel affect overall processing time and green card strategy?
Okay, so that's a great question also. If you were to file your perm application and your NIW simultaneously, would that speed up your process any? Typically, it just depends on which gets approved, right? And so you would kind of have to play out based on the variables. If you were to apply for both, you would have to see how both applications work out, and you would make your assessments based off of that. Now, traditionally, you could file for concurrent I-140 and I-45 with your NIW. However, you cannot do that if the priority date is not up to date, is not current, right? And so in the past, there was an opportunity to do concurrent filing with your NIW where you could do your I-140 and your I-45, your adjustment of status at the same time. Typically, that's not really a strategy anymore because everybody has backlog. The only time that's really beneficial or advantageous at this point is if the priority date is actually current for your national, your birth country. So that could be an option, but given what I'm seeing with the backlogs, I don't think that that's really an advantage. It used to be, but it's not right now because the backlogs are so they're retrograded by close to 2 years now. for most people or more. So
Perfect.
Yep.
Okay, so now, okay, is it generally permissible for someone to file an NIW petition while still on OPT, and would having a pending NIW alongside a cap exempt H1B filing raise any issue with USCIS?
This is a great question. So, the NIW clarification or a misunderstanding of the NIW is that they think it's a one-step process. It's actually a two-step process. So, the NIW is two-step process. I-140,
Mm-hmm.
and then when your priority date is current, then you can file your I-485. Now, that leads me to answering your question. An approved I-140 does not put you in a grace period with your visa. If you are living and working in the United States, you must keep a valid visa during that time period.
Mm-hmm.
Only at the time which your I-485, that second step after your priority date becomes current, that's when you enter into a grace period. And it's it's a very short window of time because there's quite a bit of time between filing your petition and filing that adjustment of status. So all of that to say that filing for the NIW while you're on OPT, while you're on H1B, that F1, those are all typically valid choices for you. There's no interference. The I-140 itself doesn't have immigration intent, so it doesn't conflict by itself. It's just when you file that I-485 is when you file your intent. So if you have an H1B and you're on cap exempt or non-cap exempt, typically it's grounds for extension. If to have an approved I-140, that can be grounds for extension of that visa. Now for your OPT, you have the option of OPT STEM sometimes. Day one, you would want to keep a valid visa until your adjustment of status is approved. So working with a legal professional for immigration professional would be advantageous to you during that time period because it would be important for you to stay here in a valid way during that time period.
That's a good one. Now there is one more question. For the drafting of case, how much material do the client should bring? How many pages are needed at least for your team to start drafting?
How much pages do you need at least for your team to start drafting? Okay, so this question is a little bit different. So I think there's a slight misunderstanding here. If you wanted to work with our team, I think the first thing you would do is you would go to our website. I think it's on this presentation. You go to our website, complete our free evaluation, and see if you have a strong alignment to the NIW framework. Based on that feedback, if you want to then retain us and we say, our feedback comes back that you have a strong case, we invite you to retain us. And then if you choose to retain us, you would get assigned a case manager. And so it's not about how much material the client should bring. What we are looking for is sufficient evidence and sufficient alignment. So it's not a quantity, it's a quality matter. And so all of that to say that, at the time of retaining us, we do have different kind of checklists that we go through that may be relevant to your industry, and we try to build up as much of that as possible. So it's not a numbers game, it's a quality. And so in that regard, what we would want to do is we would want to look at your resume. We would want to see what we need to support how you've distinguished yourself and the quality that you bring to the table. And could that be done through, 5 or 6 pieces of evidence? Maybe, but more likely than not, we're going to need, your transcripts, any kind of memberships, awards, recognition, all of those kinds of things, any kind of letters of recommendation that we can acquire, any kind of thing that you've done to distinguish yourself. So it can come in a number of different ways, and there's no one single way that it works for each client. The USCIS is flexible in that regard. They do allow some flexibility for how we get there. They just want to see the quality, sufficient quality of what we do submit. So I hope that helps answer that question.
Yep. And now the next It's not a question, but it's a review from a client that I have received my EB2 NIW case approval through your law firm, and I'm truly grateful to you for that. You personally reviewed my case, and thanks for that. So,
Oh, that
thank you
makes us
very
very
much. Yes.
happy. That is so nice of you. Thank you for sharing your testimony with us. It's a pleasure to be a part of your journey.
Yeah, we are very grateful for that. Okay, so let's see if we have any more questions coming. No, okay. So I have one more question for you.
Sure.
What is the role of the PE in overall application, and how does it relate to an national interest?
Yeah, thank you for this question. I love this question. The
Mm-hmm.
proposed endeavor is really the backbone of the petition. The USCIS will actually be evaluating that proposed endeavor against your advanced degree earned, against the national importance, substantial merit, against your well positioned arguments for your background, your experience, your expertise, and achievements, and against that third factor, which is the urgency, the combined urgency and contributions that you've already made to the US. So it's interesting because different from, and I won't go on this tangent, the EB1 is a lot more like resume stacked in the sense of yes, you still have future plans, but we're spending a lot more time just focusing on, hey, I've accomplished all of these things. Please, please grant me a green card. Please grant this visa to me based on merit of what I have achieved. And that's a
Mm-hmm.
different tone than the NIW, which is the NIW is I have these future plans. Look, I meet the qualifying record of education requirement. Look, my future plans have national importance. Look, I have achieved enough to say that I can do these things in the future. I do have exceptional ability. Look, I am doing something. My proposed endeavor is of urgency. It is of contribution to the United States. It will benefit the United States, and I have already benefited the United States. And so it's a different argument, it's a different threshold, and it's a different way of thinking. Both require future plans, but in the NIW, especially, that proposed endeavor cannot be understated. A lot of times, people misunderstand that and they think that it's not as important as it is, but honestly, the NIW, the USCIS, if I have to focus on one piece of evidence, a lot of times clients can look really, really great on paper, but the USCIS will come back and say this proposed endeavor is too vague, I can't verify anything else. And so right away you see the value of the proposed endeavor is because they compare all of the framework analysis to that proposed endeavor. So it's critical.
Nice, that's so nice. Okay, so yeah, there are many of them who are telling us good morning and good evening. For all of them, hi, good morning and good evening.
Yes, good
Okay, so
morning.
yeah, I'm currently in Dubai, so for me it's good evening, and I think for you it should be good morning, right, Chelsea?
That is correct. That is
Yeah.
correct.
Okay, so we will move on to our next question, which is who has the burden of the proof in showing that a petitioner would benefit U.S. national interest?
That burden is on the petitioner to prove that. And if you work with a legal professional, then they help you to achieve that standard. They'll help you to develop that argument and help you to develop, through research and evidence that you can provide to, show the national importance, to show that there's value to the United States for your future plans and what you've already achieved. But ultimately, that burden is on the petitioner to achieve it. But if you work with a legal professional, then you get some support in that regard.
Nice, that's perfect one. We'll move on to our last question, which is what happens after the NIW petition is approved, particularly regarding I-140 and work permits.
Right. So this is a common question. Most of our, I won't say most, but a good number of petitioners or clients that we work with are actually living and working in the United States, and they want to continue living and working in the United States throughout this entire process. And so they have this question about, hey, I'm currently on OPT or I'm currently, on H-1B, and what's going to happen when I have an approved I-140? Will I need to continue working with my current visa? And the answer is yes. The answer is very much yes. You still need to keep your visa active. You actually don't get a work permit from the NIW, the I-140. You get that work permit from the I-485, typically. Now, the caveat is for somebody who is on H-1B. If you are in a situation where your H-1B cannot be extended, an approved I-140 can help you continue to stay in working status for that time period. There are some special nuances for spouses. If your spouse is living here at the same time, say you're on H-1B, they can get H-4 EAD sometimes. It's all really circumstantial. It's all really individually based, whether you qualify for those narrow channels of EAD, but typically the petitioner itself, the beneficiary themselves, an approved I-140 alone isn't sufficient grounds for an EAD, typically. But the approved I-45 is sufficient grounds for the EAD, typically.
Nice. We have one more question. So we've been hearing that the current administration may cancel the EB to NIW program. How true is that? Will those of us who have already received approval face any issues regarding that?
That's an interesting question. I actually haven't seen any confirmation of that. I haven't seen anything that seems substantial that the EB2 program is being canceled or is in jeopardy of being canceled. Currently, the administration and the White House has stated that they value international contributions to our economy and to our industries. The thing that I've seen from what they've released, and again, that's the thing to know about current, like federal policies, is, until it's announced, it's really just kind of hearsay. We don't really get to know a lot of things in advance. So what we know from the tone of the White House right now is typically that they're really wanting things to be highly legitimized. So we're seeing higher levels of evidence being required in the NIW. We're seeing discussion of a possible rule for the H-1B, increasing, the filing fees and all of that, because the rationale that was released is that they had issues with companies circumventing talent for a reduced rate. They felt, and so that that whole issue that they're trying to do, I have not seen anything that supports cancellation of the EB2 NIW program. My understanding right now is that they're trying to get their arms around the program through the requirement of higher evidentiary requirements. That is my current understanding. And based on that, I think that, what we've seen so far is that things that were approved are generally being honored, so long as there wasn't fraud involved in that, initial approval. That's those NOIDS kind of things going on. So my understanding is that the AB2 is still going to happen, maybe just under heightened evidentiary scrutiny.
Perfect.
Yeah.
So,
And similarly, I think we had a question about the shutdown. The shutdown should not impact processing because it's typically funded through a different source. It's funded through petitioner funding fees and different things like that. So they have a different budgeting source. So for those living in the United States, from what we've seen, the USCIS may operate slightly slower, but we haven't seen any kind of indication that there's a shutdown that's impacting USCIS processing. Now that could be different for those who are doing consular adjustment of status kind of, appointments. We may see longer delays in that side of things because those are more embassy appointed positions. But again, from what we can tell and from what they've told us so far, that it's still operating, just maybe slightly delayed.
Thank you so much. Thank you so much, Chelsea, for addressing those so clearly. And I am sure that our viewers really appreciate your insights and practical advice on this topic. There is one more question, which is in Bangla. Okay, so I do not understand the language, so sorry for that.
I don't either.
Yeah, so I'm so sorry for that, Sohab Udinalam. I wish there was a, I wish
A
Raju sir
translator.
was here. Yeah, he would
Yeah,
have helped us in this. But
absolutely.
we will for sure keep this question in the mind and we will ask our management team and get back to you. Um, yeah, so before we wrap up this session, do you have any advice for those people who are currently preparing for the NIW petition?
I do. My bit of advice would be to think about your future plans. Think about them in a way that really steps outside of your comfort zone and focuses on what is exactly unique and niche to your expertise, and try to align that to an important issue in the United States, something with federal funding, something with federal focus, and see where that takes you. I think those are great building blocks. Start thinking about evidence that you may be able to leverage, whether it's letters of recommendation, whether it is evidence of your salary, awards, recognition in some way. And if you're not quite there yet, if you're not quite at the threshold for having a strong NIW, my best advice is to get involved. Get involved with something at a national level, at an international level. Get involved. Continue making steps toward that achievement, and you'll get there. You will get there, and it will be, something that you can thank yourself for putting in the time to do it so well. That being hiring in with maybe a nonprofit, working with some kind of federal funding, working on projects that receive federal funding. All of those things can play in to demonstrate how you can have a broader impact, how you can show that you are working on something that's aligned to federal interests. So that would be my biggest advice. If you aren't already at that threshold, make steps to get involved in that way. And that would strengthen your case. That would get you there. When in doubt, working with a legal professional is always helpful. Continue to stay in touch, and we hope to be part of your immigration journey best we can.
And I just got a translation for this. The guy is asking that how I can talk with Mr. Raju Mahajan in Bangladesh.
Oh, if you want to
Yes.
speak with Mr. Mahajan, we schedule appointments on our website, and that would be the best way to do that. If you have any trouble, you can reach out to our team info@rajulaw.com, and they can coordinate. Mr. Mahajan's schedule does kind of fluctuate a little bit, and so if you have trouble scheduling online, reach out to them, explain your wishes, and we'll do our best to connect you.
Thank you so much. Okay. Thank you so much, Chelsea, again for joining us today.
And I'll add
And
this back here. Just
yeah,
adding this back here for just a moment so they can grab this website information and email.
sure. For sure,
But
no
that's
worries. So as you can see, we have a website over here, www.rajulaw.com. You can also email us over info@rajulaw.com. And there is a number over here, +1-833-725-8529, which works 24/7 hours. So please reach out to us anytime you want.
there you go. Perfect. Thank you so
And
much.
yes, thank you so much, for Chelsea, again for joining us today, sharing your expertise with our audience. It's been pleasure having you with us today.
Thank you for having me, and thank you for your great questions, everyone. Have a great day.
Have a great day. Thank you. Bye bye.
Bye-bye.
Okay, and that's all for today's Monday Live. Thank you everyone for joining us. Don't forget to follow our page for upcoming sessions and the latest immigration insights. And remember, Immigration for All goes live every Monday, 11 a.m. EST, 9 p.m. Bangladesh time, and 7 p.m. Dubai Standard Time. Before we close today's session, let's take a quick look at the latest immigration news updates from this week. Until next time, this is Manshi Katira signing off. Stay informed and stay inspired. Thank you very much and goodbye.
Hello everyone, welcome to this week's immigration update from Raju Law. We bring you the latest news, USCIS updates, and policy changes that matter. This week's top stories include Trump plans new H-1B restrictions, illegal border crossings hit 50-year low, ex-Marine appointed to lead immigration courts, Pope Leo urges bishops to speak out, judge blocks ICE detention of 18-year-olds. Let's start with the H-1B visa updates. Following the proposed $100,000 H-1B visa fee, the Trump administration plans further restrictions by December 2025. The new rule would tighten eligibility, limit cap exemptions, and increase oversight of employers and third-party placements, echoing a previous Trump-era rule struck down in court. Now to major news at the southern border. DHS data shows illegal crossing in the US-Mexico border are at their lowest since 1970, with just 238,000 recorded this fiscal year. Under Trump, monthly crossings dropped below 9,000. The White House credits stricter enforcement and troop deployment, while advocates urge Congress to pair border control with long-term immigration reform. Moving to a new appointment at the Justice Department. Retired Marine Colonel Derek K. Margolin has been appointed to head the Executive Office for Immigration Review, which oversees U.S. immigration courts. Margolin dismissed from Marine Base Quantico in 2013 for a firearm violation. Previously served as an Assistant Chief Immigration Judge. He now inherits a record 3.8 million case backlog. Next, a strong message from the Vatican. Pope Leo XIV met with El Paso Bishop Mark Dates, receiving letters from migrants affected by mass deportations. He vowed to stand with immigrants and urged U.S. bishops to speak publicly against inhumane immigration policies. The first U.S.-born Pope said, "Compassion must extend to those fleeing violence and persecution." Finally, a key court decision on migrant youth. A federal judge has blocked ICE from transferring unaccompanied minors to adult detention once they turn 18. The ruling holds a new policy offering $2,500 to minors who agree to self-deport. Judge Rudolph Contreras said the plan violated a 2021 injunction requiring less punitive alternatives for age-outs. That wraps up this week's immigration updates. Stay connected with Raju Law for more news, insights, and guidance. See you next week with the latest developments in U.S. immigration.